Good morning, everyone. Welcome to Thompson Hine's Startups Streamlined monthly webinar series. My name is Jasmine Hurley. I'm not your usual host, but I'm your host for today. I'm Managing Associate in Thompson Hine's New Ventures Practice Group. Joining me today is Marla Isbicki, Counsel in Thompson Hine's Privacy and Cybersecurity Group. Marla has extensive experience advising U.S. and international companies on a wide range of privacy and cybersecurity issues. She counsels emerging and established businesses on dynamic privacy laws and other emerging state privacy laws, and helps them integrate privacy by design into their operations by drafting public-facing privacy policies, terms of service, and international privacy frameworks. Today, we will be discussing the evolution and proliferation of privacy laws in the U.S., as well as their key differences and similarities. We will explore essential protocols that companies should consider when developing and reevaluating their data privacy compliance. So if you have any questions or comments, we encourage you to join the discussions. You can either use the chat box or there's a Q&A chat box in your control panel. We will try to do our best to address your comments and promise to follow up on any questions we don't get to during our time together. So with that, let's get started. Hi, Marla, how are you?
I'm good, Jasmine. How are you?
Fantastic, fantastic. Thanks for joining us today. So we've got plenty of amazing questions, but let's start off. So how many privacy laws are we up to in the United States right now?
Well, in this very moment, we are up to 10 passed and signed, and another 2 passed but not signed. And I say in this very moment because it is changing by the minute and by the day. If we looked at this in the beginning of the year, we would have had like 2. But just in 2023 alone, we are rapid firing new state laws every week with more laws in the pipeline. Like I said, we've got Delaware, we've got Oregon coming, and who knows what other states are going to get more active and throw some new laws our way.
Who have been the most active states thus far?
So California is, of course, leading the way. It was kind of like Europe started and then California went, we've got this, and really kicked us off in 2018. And they've been active since, even doing a whole revamp and reassertion of what they meant in their 2018 law, which is commonly known as the CCPA, by doing what's now called the CPRA in 2020, which will go into effect in 2024.
So with all of these laws that have been passed or about to be passed, what are some of the key similarities? Are there key cornerstones to all of these laws? And then what are some of the differences that our startups and folks need to look out for?
Absolutely. So on the one hand, it's great because a lot of the laws are following a similar pattern. They kind of took the California model and are following what they like and not following what they don't like. But it's not a one-size-fits-all. So if you say, you know what, I really like the Connecticut law that just went into effect in July, well, you might not be fully compliant with all the other states. So it's important to take a look at what those key differences are. For instance, at the outset, it's a threshold question. Each state has thresholds that you have to meet in order to fall under the purview of that law. If you don't meet those thresholds, great, you're not subject to that law. After you go through that, it's like, okay, well, what kind of data might be exempt? Some laws don't govern certain data, like HIPAA data or financial data that might be subject to, the GLBA, for example. So those are all differences that you need to go through, because the last thing we want to do is make you subject to a law that you don't have to be subject to. But once we figure out what I like to call the highest common denominator, which is the most strict that you are applicable to, we can take that, write all of the policies, internal and external, that you need, and then have that apply so that it covers all of your bases for the rest of the laws that are currently in place or that might be in place soon.
Now, you mentioned, as you're going through, you said not all of the laws apply, not everything is governed by one particular privacy law. There are different privacy laws that govern different things. What are some of the more common, especially for those companies that are working in tech, whether it is business facing or consumer facing?
Yeah, so the biggest thing we want to be thinking about if we're especially consumer facing and in tech is consumer control. What a lot of these laws are giving us is the ability for consumers to have a lot more control over their data once they've given it to us. And that includes the ability to not give it to us. So key points are things like the ability to opt out of giving data, the ability to opt out of you getting to share or sell that data, you being the company, the ability to unsubscribe from marketing, the ability to say, what data do you have? Show me the data that you've collected on me. Some states can let people correct that data if it's wrong. Some can ask you to delete it completely. And some can say, I want to take it and I want to transfer it somewhere else. And so there's a lot of mechanisms in place to give a consumer a lot of rights, which means there's a lot more onus on the company to have protocols and back-end programming in place to have to then honor what those rights are.
Now you talked about control, but are there other things that pop up when it comes to the data that is being gathered by companies?
Yeah. Another big theme that we see in data privacy and in these laws is transparency. People just want to know what you're doing. One of the best ways we do this is the privacy policy. Who among us hasn't gotten a, hey, we've updated our privacy policy email? Well, we do that and companies do that because we want to be constantly pushing towards the consumer, whether that's a business or a B2C company, that this is what we're doing with your data. We're collecting this data by you giving it to us. So you're filling in your email address, or we're getting this data through cookies. And we can get into cookies another time. Or we're getting data by seeing that you connected with your Facebook or Instagram or Twitter or whatever social media. So there's multiple ways to be getting data. So you tell the consumer, that's how we get it. Then we tell the consumer, and this is what we do with it. We use it for marketing. We use it for analytics. We use it to process your purchase. We tell the consumer who we give it to. We're giving it to our marketing agency. We're giving it to an analytics company. And then we tell them all the rights that they should know already, but we've got to tell them again. So it's the transparency there where we're just spoon feeding in plain common language everything that we think a consumer needs to know about our site and their data and how it interacts. And then most importantly, we give them a means of communication because we can't just be that ether floating out there with their data. They need to know how they can contact us to get that control back over their data.
Awesome. Now, what about security? I know that that is also a big theme and a big issue when it comes to privacy. You know, companies are gathering this data. What happens, and what should they be thinking about when it comes to security?
Absolutely. So if you have not taken, you being the company, have not taken proper industry level precautions to secure the data you have, or working with a vendor that secures the data, and something were to happen, a breach were to happen, a leak were to happen, that might fall back on you. And that's the case written into some of these privacy laws. If, however, you've done everything by the book, you have end-to-end encryption, you have training for your employees on who's allowed to access data and who's not, you have agreements in place with your vendors in terms of what they're allowed to do with their data and how they're supposed to tell you if they've had a breach. Well, then you have a better argument of, we did everything we could, and now X, Y, and Z incident response plan will happen. But it's important from the very first moment that you have protections in place so that you can assure your consumers, your customers, as well as whatever government agency is overseeing you, that you did what it was necessary to protect that data. If you've just got data kind of hanging around in your email, well, that's probably not going to cut it should the worst case scenario happen. Then If that worst case scenario were to happen, that's when you would have to then still come to a data privacy and cybersecurity professional so that as soon as possible, we can hit the ground running with an incident response plan because many states, almost all of them, have requirements on how fast you have to respond, what you have to do, and who you have to tell.
Thank you for that. I know those are some key things and concerns that a lot of folks have brought up to us over the last, I would say, 6 months. I don't think anyone is not aware of any breach that has happened ever in their information. We've all received those letters, and that's part of the response that's required in most states for cybersecurity breaches. And what's the best way for companies to really understand what the requirements are under each state's law? Since each state is not exactly the same, what's the best way for them to understand that?
Well, I've got to admit, I'm going to, of course, say that you should contact me or one of the great other privacy attorneys here at Thompson Hine. But even before you do that, just take a second and think about what data you have. Think about what you're getting, where you're sending it, how you're using it, and think about where you're doing your work. Like I said, new laws are coming every week. So if you thought before, well, we don't really have a presence in California, well, now you might have a presence in Connecticut or Virginia or Colorado or Montana, and the list goes on. So just think about where you're working and where you might be working and consider what the risk is to you. Is it better for you to risk a potential fine that comes from breaching one of these privacy laws? Or is it a better investment at this time to come to an attorney that we have here at Thompson Hine and figure out both the quick fixes, the long-term fixes, whatever's necessary to get yourself compliant so that you're not looking at fines down the road? The best thing you can do is get ahead of the laws so that as more laws come out, you're doing slight adjustments and not reinventing the wheel every time a new law comes out.
Now, you mentioned, not just what do they have, but where are they working, right? When you say where are they working, can you dive into that a little bit more? Is it where they actually have their headquarters, whether they are physically in the state, or is it a little less of a threshold for that particular criteria?
Yeah, so if we think about today's society, it's not, where's your factory set up necessarily anymore. Sure, there's a lot of companies that might be like that. Where's your office? Where's your factory? But especially a lot of the new ventures and the tech new ventures, we're not thinking in terms of geographic locations, we're thinking of people. Where are your people? And when I say your people, I mean consumers. And they could be across the country. So if you think of who's my target audience, well, oh, I have a lot of users for my app over in Indiana. Well, Indiana has a privacy law. I need to consider whether I have enough people in Indiana that I'm subject to that law. When you think about where I'm working, think about who I'm working with. And that means the data subject. That's the official term that we have for people, the people whose data we're collecting and using.
Now, Marla, you know, anyone can use the internet, whether they're, internally to the United States or external. What about those companies who they happen to collect data from someone who is outside of the United States? So they might be governed by the GDRP or that particular country's laws. How should they handle that data collection and those sorts of data issues that might arise?
Absolutely. If your company is specifically working and targeting consumers in the European Union or UK, you should really be contacting a privacy professional because you're subject to what's called the GDPR. The GDPR is the original mothership of privacy laws, and they take their privacy in Europe very seriously. So seriously, in fact, that fines for not following the GDPR can be up to 4% of your annual global gross revenue. That's how seriously they take it. Those are the fines that you're seeing from Meta and Amazon and so forth. So if you are specifically working with the European Union, make sure you contact someone. Now, if you have an occasional European Union resident who's accessing your website or giving you information, that's slightly different. That's a conversation that you really need to have with an attorney about whether you've then crossed into the threshold of needing to follow the GDPR, or whether you need to just have proper disclosures and covering your bases. There's not necessarily a one size fits all when it comes to interacting with the EU and the UK. If you're functioning in places like Brazil or Asia or Canada, well, those all have different laws too. In fact, even Quebec just came out with a new law about what happens if you transfer data out of Quebec to anywhere else. Important things to be considering, even if you're not personally doing it, but one of your vendors are. It's taking stock of who all you're getting data from, whether it's a vendor, a consumer, and where you're sending it to and why.
So this becomes even more important for those businesses that are looking at international expansion outside of the borders of the United States. So many moving parts. I just want to remind everyone, more than, we're fielding any questions. So if you have any questions, please put them in the chat. I'm more than happy to ask Marla. We won't say your name if you don't want us to say your name. So feel free to pop those into the chat if you have any questions before we wind down. We've got about a little over 10 minutes left. But what are some of the key takeaways or best practices that companies should be using, looking for as they either start along this privacy journey or are looking at revamping their policies?
Sure. So the first thing I like to think about is don't say to yourself, I'm not in the business of data. This doesn't apply to me. Almost every company, I won't say all, but almost all the companies have some type of data business involved. Let's say you're shipping logistics. You're like, I'm not in the business of data. I'm in the business of shipping logistics. Well, you've gotten someone's address, haven't you? You're shipping to an address. Well, that's considered personal identifiable information. That is the protected information we're talking about when we're talking about what the data privacy laws are governing. So that alone means you're in the data business too. So don't count yourself out because you think you're not in the business of data. All companies are dealing with data in one way or another. On the flip side, don't think that, oh, data is mine. That's how my business model is running. I've got this data and I can do what I want with it to make my company work. As we've already talked about, the data, when you get it, it's not yours. It's still the consumer's. We've got the control, the transparency, and the security. Those three words should always follow in your head when you think of data, because you can't do anything you want necessarily. We can work on it. We can make sure you're doing it correctly so that it can still fit into your business model. It can still meet your goals, but we want to do it in a compliant way so that later on, you're not getting a call from some state's attorney general saying, hey, the way you used that data, you weren't supposed to. You get ahead of it, especially my new venture clients I love the most, because we get in at the ground level and we make sure it's privacy by design. It's built right in from the start that we're doing this in a compliant way so we don't have to fix it later and we don't get any letters from the Attorney General.
So you want to say, I guess your third point is avoid the bad side of privacy laws, right? Avoid the Attorney General.
Always avoid the Attorney General. Listen.
Avoid the Attorney General, always.
Sometimes, almost like a data breach, sometimes some things are unavoidable. I, once upon a time, was in litigation, and we used to say, it's not always up to you if someone sees you. It just happens.
Right.
Things can just happen. That's the case for all businesses. As long as you've got a competent, trained, and experienced privacy attorney on your side, whatever comes your way can be handled, can be approached, can be a not oh no moment, but instead of we've got this moment, which is even more of a reason to have a privacy professional with you from the beginning and then around in the background should you need them.
So, Marla, how can folks contact you? Should they have questions afterwards, or and are you also on LinkedIn so folks can connect with you there?
Absolutely. I'm on LinkedIn. Look me up. My full name is Marla Isbicki. It is spelled just like it sounds. I'm also on the Thompson Hine website. My email address is marla.isbicki@thompsonhine.com. We're welcome to call, email, LinkedIn message me anytime. I am happy to talk, even if it's just a crazy theory about, hey, is my phone listening to me when I'm talking about things? How did this app know that I was thinking about toothpaste? Always happy to talk about data privacy.
We'll talk about that offline, because I'm also wondering how that happens. Sometimes when I say I need milk, and then all of a sudden Kroger is like, you need milk. How do you know that? Well, to recap the best practices that Marla put out there, she just reminded us you are in the data business first and foremost, regardless of what your business is. You are constantly gathering data on your clients, your customers. You do not have free control over that data. Go back to the three. I like the three you've got there: control, transparency, and security. Avoid the attorney general, right? And keep calm and call your privacy attorney. If anything happens, keep calm, call your privacy attorney. Well, Marla, I just want to say thank you so very much for chatting with us today and answering our burning questions. That concludes today's discussion. Unless there are some last minute questions that folks may have, do want to remind you that this webinar was recorded. So you can find it in our library of recordings on Thompson Hine's YouTube channel. We encourage you to visit our YouTube page and subscribe to stay up to date on all of our content. You can also see some of our past Startup Streamlined videos on there. We want to thank you all for attending today's program. And again, we extend a special thank you to Marla for sharing your insights. When the webinar ends, you will be prompted to take a survey providing feedback. Thanks again, and we really hope you enjoy the rest of your day and stay well. Thanks.
Thank you.